Question number 63, which has defined a gift and the essentials of a gift. So the very answer we found under section 122 of the Transfer of Property Act, which defines a gift as transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the Donee and accepted by or on behalf of the donee. A gift is undoubtedly a transfer which does not contain any element of consideration in any shape or form. In fact, where there is any equivalent or benefit measured in terms of money in respect of a gift, the transaction ceases to be a gift and assumes a different color. The motive or the purpose of making a gift should not be confused with the consideration which is the subject matter of the gift. Love, affection, spiritual benefit, and many other factors may either in the intention of the donor to make a gift, but this filial intention, consideration cannot be called or held to be the legal considerations as understood by law. It is manifest, therefore, that the passing of a monetary consideration is completely foreign to the concept of a gift, having regard to the nature, character, and the circumstances under which such a transfer takes place. So, Section 122 of the Transfer of Property Act thus clearly postulates that a gift must have two essential characteristics, and that is, it must be voluntarily and that it should be without consideration. So, in the very leading case, Sonia Bhatia versus State of Uttar Pradesh in 1981, Supreme Court felt that this is apart from the other ingredients like acceptance of the gift or the essentials of a valid gift, and in that particular ruling the Supreme Court expressed that the essentials of a valid gift are: the first one, there must be transfer of ownership of existing property, and second one, the ownership must relate to a property in existence, and the third one, the transfer must be without consideration, and the fourth essential of a valid gift is it must have been made voluntarily, and the fifth essentials of a valid gift is the transferee must accept the gift as it was expressed or pronounced by the Supreme Court in 1991 in this leading case, Sonia Bhatia versus State of Uttar Pradesh. So, we'll discuss the first valid essential of a gift, that is transfer of ownership. So, as in case of a sale, there must be a transfer of all the rights and the property by the donor to the donee. It may, however, be noted that it is permissible to make conditional gifts. The only restriction is that the condition must not be repugnant to any of the provisions of section 10 to 34 of the Act. And now we'll go to the second essential validity of a gift is existence of property. And the secondly, although a transfer may take effect in present or in future, but it cannot be made of any property which is not in existence at the date of the gift. Where a gift is made of a property which is not in existence, Section 124 of Property Act declares such gift to be void. So, in that connection, we would like to discuss two important decisions. One is T.B. Suhama versus T. Ratama in 1987 Supreme Court expressed that the question was whether gift by a co-partner of his undivided share is in co-partnership property without the consent of all the others is valid. The Supreme Court said no, it is void and unenforceable as the very consent of all other co-partners in that property was not taken. And in that connection, we would like to discuss another important leading case, and that is Munilal Mahato versus Chandreshwar Mahato in 2007. The Patna High Court expressed that the question involved was gift of share in the co-partnership property without consent of co-partners. But facts were slightly different. In Munilal's case, the gift was made after preliminary decree for the partition. Here, law is different. The preliminary decree of partition amounts to severance of status of joint family. That is, end of co-partnership. The parties are no more co-partners. They become tenants in common in joint possession. The shares are definite but physically undivided. This can be gifted. The joint family need not to continue till the physical division of all joint family properties by meets and bounds has taken place. The gift was upheld. T.V. Swama held not applicable on facts stated. So now we'll go to another important element that consideration, and here we would like to also discuss the provisions of section 25 of Indian Contract Act of 1872. So the essence of a gift is that it is a gratuitous transfer. The word consideration is used in the same sense as in the Indian Contract Act of 1872 and excludes natural love and affection. A transfer in consideration of an expectation of spiritual and moral benefits or in consideration of natural love and affection is a gift. It must, however, be noted that gift must be complete in law. If there is only an agreement of gift, it is void under section 25 of the Contract Act, unless the agreement is in writing and made on account of natural love and affection. between the parties. And now we'll go to the next essential, that is voluntarily. The word voluntarily signifies the exercise of the unfettered free will. A man cannot be said to be truly willing unless he is in a position to choose freely, and freedom of choice predicts not only full knowledge of the circumstances on which the exercise of choice is conditioned, so that he may be able to choose wisely, but the absence from his mind any feeling of constraint, so that nothing shall interfere with the freedom of his will. Thus, where undue influence and pressure has been exercised on the donor, it is clear he has not made the gift voluntarily, as it was held by the Privy Council in the Allahabad leading case Pulchan versus Luku, and also in another important leading case decided by the Privy Council, and it was the case of Calcutta. If gifts are made by per the Hasan ladies, it must be established that the transaction was understood by the lady and that she had opportunity to take independent advice and was a free agent, as it was pronounced by the Privy Council in this Calcutta leading case, that is Wajia Khan versus Iwaz Ali. So now we'll go to another one, that is undue influence. It is a well settled law too. Undue influence is the same in the case of gift inter vivos as in the case of the contract. So in the leading case, that is Subhash Chandra Das versus Sarju Prasad in 1967, Supreme Court expressed that undue influence must consider the following two important things. One is, are the relations between donor and donee such that the donee is in a position to dominate the will of the donor? And the second one is that has the donee used that position to obtain an unfair advantage over the donor, as it was pronounced by the Supreme Court in 1967 in this leading case Subhash Chandra Das versus Sarju Prasad. And now we'll go to the last one, that is acceptance by the donee. So, donee need not be in a sui juris. A gift therefore may be made in favor of a minor, but such minor, when he attains the age of majority, may avoid the gift. The donee must be a suitable, tenable person or persons. A gift cannot be made to the public or society at large. The gift must be accepted by the donee or by someone on his behalf during the lifetime of the donor and while he is capable of giving. So, in the important leading case, Bancha Bhodo versus Sharia Bewa in 1973, the Odisha High Court pronounced that when the subject matter of the gift was enjoyed jointly, why the donor and the donee mere possession cannot be treated as evidence of acceptance as it was pronounced by the Odisha High Court in 1973 ruling regarding acceptance by the donee in this important leading case Bancha Bodo versus Saria Bewa in 1973. So the answers that we have discussed as relating to section 124, so also regarding section 124 and as relating to the corollary provisions of section 25 of the Contract Act and all these important leading cases and all those essential elements of a gift such as transfer of ownership, existence of property, consideration, voluntarity, and also undue influence and acceptance by the donee are the correct and appropriate answer to question number 63, that is define a gift and the essentials of a gift. So this should be the correct and appropriate answer to this question number 63. So in our upcoming videos we will discuss all other questions that we have framed in relation to law property.